Should I go ahead? Write down Supreme Court on what? Material resources. Supreme Court on material resources of the community. Material resources of the community. Right? So 2-3 things like we always do. What is the first thing that you'll do? Yeah, it's tricky. I know it's tricky, but don't worry. I will make it less tricky. What is first thing that we'll study here? First, you got to look at the background. Background is simple. Constitution is tricky, written by lawyers. It has to be tricky, and lawyers in those, English educated, so they will write in a tricky. Laws are very tough to understand. But if you understand the knack, you have to be patient. You would like to throw that book away. If you just pick up and be patient, you understand. So we'll simplify, don't worry. First, you got to look at the background. Then, yeah, very good. Then you look at the constitutional provision. Constitutional provision, then judgment. Then analysis. I was thinking we might get free a bit earlier today, but I think if I think earlier, I think I'm not doing justice, so I want to explain it to the fully. Otherwise, you'll not understand. These are tough topics. For every topic, you need to pick up that hint, which takes time. If you understand that hint, then you are done and dusted for all your 6 attempts. Right? Because all of you will give your first attempt, so not for you, don't take it otherwise. So, background, constitutional provision, judgment, analysis. At the end of the day, what is this judgment all about? If I just go into the heart, I tell a common man on street, rickshaw wala, idhar aa, 39 bhi pata, bola nahi pata. Ye Supreme Court ne decision diya hai kya? Classic debate hai ye. You know this debate, FR versus fundamental rights, FR versus DPSPs. That debate is the debate here. Aur kuch bhi nahi hai isme. See, there are 2 things. At one point, if I want to just look at this, judgment, there are 2 parties involved in this judgment. Or let's say this larger debate. 2 parties means one is you and me. You and me as an individual. All of us are individuals. We enjoy fundamental rights. Am I right? So, you and me as an individual. Individual, I'll attach one more term, private property. This iPad is my private property. This laptop is my private property. This stylus is not my private property. Your iPad is your private property. That's a simple thing. So, individual has got private property, which used to be a fundamental right. It used to be there in Article 31. Then you said it used to be there in 31. Then all of you know it, like it's the simplest, most popular fact in polity, that this 31 was before 1978. Came 44th Amendment, Mr. Desai, in the aftermath of emergency, so took a hyperactive step and said that I'll make right to property a constitutional. Don't worry. Constitutional right is in the Constitution. Fundamental rights are in the Constitution. Fundamental rights are constitutional rights. But all the constitutional rights are not fundamental rights. Like this. Every individual has got right to property, save by law. Right to property. I have got right to property. As per Constitution, it's a constitutional right. And thereby, to fulfill the constitutional right, the laws have been passed by the legislatures. Land Acquisition Act is what? It is manifestation. It is fulfillment of द कॉन्स्टिट्यूशनल राइट टू प्रॉपर्टी. मेरी जमीन आपने ले ली, मेरी प्रॉपर्टी, राइट टू प्रॉपर्टी है, कॉन्स्टिट्यूशनल राइट है. इट गॉट फुलफिल्ड थ्रू अ लॉ, so it's a legal right also. There's no dichotomy. Civil Rights Act 1955 is a law. It prevents untouchability. That is a fundamental right as well as a constitutional right. To fulfill that, we also made a law. It became a legal right. तो कोई डायकॉटमी नहीं है. एक तरफ तो ये है भाई मेरी प्राइवेट प्रॉपर्टी है, ऐसा कोई नहीं ले सकता. क्या वाकई में नहीं ले सकता? क्या ले सकता है? ले सकता है, बिल्कुल, अंडर लॉ ले सकता है. बट देर इज ऑल्सो वन मोर आर्टिकल इन द कॉन्स्टिट्यूशन, दैट इज 39B. 39B, it says what? It says that it's basically, you write like this, it says that the state through policy or action, the state will launch policies, it will act. The state through policy or action acquire material resources of state or individual, material resources of community to fulfill. Subserve is what the constitution says, but I don't want to go into that term. I'll simply write to fulfill common good. Fulfill common good, society का भला fulfill करने के लिए the state can acquire material resources of the community. ये कहा है बस, material resources of the community. And एक और आर्टिकल ले लीजिए 39C. 39C, it says the economic system, economics, every economics that you study, demand supply that you study, the economic system shall prevent concentration of wealth, I'll write it here, and means of production. Concentration of wealth and means of production. That is the gist. बस उसके अलावा सारी स्टोरी है. मेरे पास मेरी प्रॉपर्टी है, आप एक्वायर कर सकते हैं. स्टेट कैन एक्वायर बाय गिविंग मी कॉम्पेंसेशन. मुआवजा दीजिए, पब्लिक पर्पस दिखाइए, जमीन आपकी. स्टेट किस हद तक जमीन लेगा? बिकॉज इट हैज गॉट ऑब्लिगेशंस अंडर DPSP which are non-justiciable and they cannot be enforceable in the court of law. The state will acquire property of the people. It might trample on these rights because 39B says it should make policies which, number one, do what? Acquire, or it gets material resources of the community. ना मेरे, ना आपके, ना इनके, कम्युनिटी के. स्टेट के नहीं, प्राइवेट के नहीं, कम्युनिटी के. संविधान कह रहा है कम्युनिटी, ना ये कह रहा है कि आपके मेरे, ना ये कह रहा है स्टेट के. स्टेट का करता तो स्टेट का ही था वो, तो उसमें कोई जरूरत थी नहीं. मटीरियल रिसोर्सेज ऑफ द कम्युनिटी फॉर व्हाट? टू फुलफिल द कॉमन गुड. एंड देयर बाय इन 39C it says that you have to prevent concentration of wealth and means of production. इसको अब इंटरप्रेट किया सुप्रीम कोर्ट ने, वेदर मटीरियल रिसोर्सेज इंक्लूड प्राइवेट प्रॉपर्टी, because it says community is made by private people, and yes, then to what extent? That's a debate. राइट नो, इज इट क्लियर? समझ में आ रहा है? अब इसको ध्यान में रखना एंड लेट्स ओपन द बैकग्राउंड which is very interesting. The story goes in 1960s. You all know your economics, right? The story goes in 1960s. Okay, you all know monetary policy better than me. You all have studied static economics. You've heard about bank nationalization. When did it take place? Yes, very good. So there was, this story started with 69, right? 1969, we did what? Nationalized banks, private sector banks. Private property is open-ended term, right? Isn't it? So basically we did what? We had gone for Bank Nationalization. Bank Nationalization Act, Indira Gandhi government, 1969. Immediately reached the Supreme Court. When? 1970. Reached the Supreme Court in 1970. How can the banks be nationalized? You have not compensated the private bank well. They all were private banks. They were not owned by the state. You nationalized 14 banks. Compensation was not given. So the Supreme Court ruled what? Ruled what? Simply, it had struck down the law. सीधी सी बात है, लॉ लेके आए आप, you have not given proper compensation. Struck down the law because proper compensation. भाई देना तो पड़ेगा ही, जबरदस्ती थोड़ी ना है. You need to give proper compensation, isn't it? Constitution says that you acquire property as a fundamental right, but you compensate the individual, isn't it? Generally, that's the rule. Any acquisition, forget polity, has to be after compensation, and that is when Indira Gandhi government understood that there is something wrong now. Because I am winning elections, because I want to uphold Sabka Vikas, and that Sabka Vikas will come how? सबका विकास करने के लिए किसी का तो विनाश करना पड़ेगा ना, और यही किया, और जमाने की सोच वही थी. Simply said, 1971 they passed an amendment to the constitution. Simple. 1971. Which amendment? All of you know more than me. Static polity. We have not got the article till now, the discussion till now. It's basically 25th CAA 1971 did what? दो चीजें थी. Article 31C got introduced. Static polity. 31C, that classic DPSP-FR debate. 31C got introduced. Said two things. Law implementing 39B and 39C. Law implementing 39B and 39C shall not be questioned. Shall not be questioned on the ground of what? Shall not be questioned on the ground of violation of fundamental rights. Violation of fundamental rights. Tell me the rights. 14, 19, by the way it is 71, so 31 was your right to property, fundamental right, and 31. कहानी खत्म कर दी गवर्नमेंट ने. कोई भी एक्विजिशन प्रॉपर्टी का किया, ये नहीं बोल सकते भाई राइट टू प्रॉपर्टी फंडामेंटल राइट वायलेट हो रही है, इफ इट इज इंप्लीमेंटिंग व्हाट? 39B, direct policy to secure material resources of the community for the welfare of the society and prevent concentration of wealth in means of production. And it added something controversial which led to the 13-judge bench, only 13-judge bench. It also said such law shall be beyond. Such law, isn't it? All of you know it. I'm not adding anything till now. such laws shall be beyond judicial review. Is it clear till now? Further, go ahead. Now came your classic judgment of polity. 1973 came Keshwanand Bharti case. Keshwanand Bharti case did what? Upheld, I'll write it here. Upheld the first part, which is law implementing 39 BC will not be questioned on the ground of violation of 14/1931. We'll not repeat it again, but struck down the provision disallowing what? Judicial review. सभी को पता है आपको. Disallowing judicial review. And then finally, emergency had to be imposed. In 1976 came the mini constitution. In 1976 came the mini constitution where we had the 42nd Constitutional Amendment Act. 42nd Constitutional Amendment Act, where what happened? What did she do? All the DPSPs, would write like this, laws implementing DPSPs part 4 shall not be questioned on the ground of violating 14, 19 and 31. 14, 19 and 31. Because now see, Keshwanand Bharti did not strike off the provision where Amendment 25th had said that if they implement 39B and 39C, then that law will not be questioned on the ground of violating 14, 19 or 31. They just extended it to all the DPSPs, and they further said that these laws, which laws? Implementing DPSPs. कौन से laws जो DPSP को implement करेंगे? These laws implementing DPSPs shall be beyond judicial review. Shall be beyond judicial review. Right? And then finally came the last, and there the problem starts. Finally came the last law, the last part of this story, background. In 1980, Minerva Mills case, the Supreme Court struck down what? The provision debarring judicial review under Article 31C. Under Article 31C. This is the story. This story began from bank nationalization, two events taking place, legislature asserting powers, judiciary striking off one bit of it, not the entire law. Clear till now? Now comes the main subject matter. Or I'd say I'll frame it like this, as we always frame. What are the broad questions to be acknowledged, to be examined and to be ruled upon by the Supreme Court? मुद्दे की बात क्या है? सवाल क्या है? पहला सवाल, first question that the Supreme Court had, first question, Supreme Court in the Minerva Mills had struck down judicial review, but it was not clear that if Article 31C was struck down entirely, was 31C struck down entirely, complete struck down, where Article 39BC with 42nd Amendment it became any of the DPSPs under what? Being implemented by law while violating 14/1931. Is it is struck down entirely? Is it completely deleted? Or post 1973, that is Keshwanand Bharti case, post 1973 part will be the status. तो पहला सवाल इसमें यह था कि जब मिनर्वा मिल्स ने 1980 में स्ट्राइक ऑफ किया, क्या पूरे 31C को स्ट्राइक ऑफ कर दिया? कि कोई भी डीपीएसपी को इंप्लीमेंट करने के लिए अगर कोई भी लॉ पारित किया जाए तो उस केस पे वो फंडामेंटल राइट्स का वायलेशन करे 14/1921, दैट लॉ विल नॉट बी क्वेश्चनड एंड देयर बी नो रिव्यू पार्ट वाज डन, बट will entire 31C get struck off, or will it restore back to the position that was there after 1973? That was the first question. And second question is, which is the main question. If material resources of community include private property or not. Include private property or not. Right? That is what we need to evaluate in this Supreme Court judgment. Number one, when Minerva Mills case in 1980 had struck down judicial review, what was the status of 31C? Was it entirely deleted, or will it be the case that was situation after 1973? And second case, what is meaning of material resources of the community? Does it include all the private property or not? Right? Let's answer the judgment first. If we can write in constitutional provisions also. So you can just write down constitutional provisions. In fact, you already know it. 39B. Write down constitutional provisions. Constitutional provisions in question is what? First we have seen is Article 39B. Then we have Article 39C. Then we have Article 31C. Article 31C. Then we have right to property, which is now what? It is now 300A. Earlier it was Article 31. Earlier means before 1978. Right? Should we go into the judgment now? Okay, now let's open the Supreme Court judgment in this case. how this judgment came, that entire story of Maharashtra authority acquiring properties because they were not in good condition, and how that case law emerged, that is not my point. We don't want to enter that entire story. That's irrelevant. We just want to look at this entire judgment. This story is good enough for you to understand. Is it fine? तो ये केस कैसे सुप्रीम कोर्ट में आया और क्या हुआ, हमें वो नहीं जानना है यहाँ पे, हमें बस स्टोरी पता होनी चाहिए. Supreme Court judgment, you can write down, has got two parts. Answering question 1 first and question 2. Question 1 and question 2. For question 1, you write down number 1, the Supreme Court had ruled. Write down, the Supreme Court had ruled that post 1973 version of Article 31C shall remain. 31C version of post 1973 version of 31C will remain, and thereby entire 31C was not struck down by the Supreme Court. By the Supreme Court, in bracket write down, in the Minerva Mills case. In the Minerva Mills case. So Minerva Mills had struck off only the portion of 31C that basically had said that any law implementing DPSPs under Part 4 will not be questioned on the ground of 14/1931, which disallowed judicial review. So that judicial review portion was struck down. Right? Rest, whatever was the situation after 1973, that was the reality. That was the first question. Coming to the second question, understanding the second question, we need to go back in the brief. To understand question 1, now we need to see the transition. The present judgment, which we'll write in a tabulated manner. This is earlier judgment, and this is the present judgment that we want to discuss. Earlier judgment and the present judgment. Earlier judgment and the present judgment. No. I'll discuss. Okay, now see, first, to listen to me carefully, this is important. Now we are trying to question the second question, that whether all private property comes under material resources or not. In this case, you write down, is this 1977 case? We need to first understand this. We need to understand this case. Write down 1977 case. This 1977 case is called as Ranganath Reddy case. Which is this case? It is called as Ranganath Reddy case. Now see, the thing is, now look at the beauty. In this Ranganath Reddy case, by 4-3, 4-3 means 4 judges in favor, 3 judges against. So basically what the 4 said, that dominated. They said, simple thing, private property would not come under material resources of the state. Simple thing, private property will not come under material resources of the state. That is what 1977 Ranganath Reddy case. Don't get confused. Minerva Mills is ending with the question 1. Question 1 I have answered. But in this case, one of the judges in minority, his name is Justice Krishna Iyer. Justice Krishna Iyer, in his minority opinion, he said something interesting. He said, all private property shall come under material resources of community. It is too less. Make it 24. Is it fine? So all the private resources was the 7th judgment decision. Krishna Iyer said what? Yeah, Krishna Iyer says, judgment said all private is not material resources. Mr. Krishna Iyer in a minority opinion said that every private property will be coming under material resources, thereby the state can acquire and fulfill it for the common good. But from this minority opinion for the next 2 decades, the discourse was set for the Supreme Court. Despite the 7 judge bench saying that this was a case where material resources will not include private property, this particular opinion of minority judge became the basic standpoint regarding whether private property comes under material resources or not. In which cases you can write down this case law, this material resources, this thought, Mr. Krishna Iyer's thought, it continued in a case which is called as Sanjeev Coke manufacturing case. In Sanjeev Coke manufacturing case, which came up in 1983, and also in one more case, this is called as the Mafatlal case. Mafatlal case. In bracket you can write down, it came up in 1997. So eventually what became the discourse? All private property is a material resource which can be acquired by the government to fulfill the common good. This became the resource because of Mr. Justice Krishna Iyer's opinion, picked by the Supreme Court in Sanjeev manufacturing case and taken forward in the Mafatlal case. Right? This matter, because of some case, the background is not important, it reached the Supreme Court. And this case was referred for the present decision, which came up in 24, just 2-3 weeks back. This came up after the referral was made to the Supreme Court in 2002. 22 साल तक हमें यही मानना पड़ा कि सारे प्राइवेट रिसोर्सेज come under material resources whereby the state can acquire them and fulfill the common good. That is what 39B says. In this case now, the first thing that the court did, present case, first thing that the court did, it overruled It overruled what? Observation of Justice Iyer. In which case? Yes, Ranganath Reddy case 1977, where the court said not all private property, not all private property, not all private property is material resource of the community. Material resource of the community. Justice Krishna Iyer said all private property will be a part of material resource. This present judgment overruled, said that सब कुछ नहीं होगा, कुछ होगा, कुछ private property will come under material resources. But what is that private property? How to determine that? This has got a list. What kind of list? Non-exhaustive, which we'll just open up. How to determine which private property will be a part of material resources and can be utilized for the common good? For that, the court give some indicators which we'll discuss. But here, the second part that the court said, the second part in the present judgment, you can write down, the court said, it said that interpretation of 39B, interpretation of 39B cannot be rooted, cannot be rooted in what? In the rigid economic ideology. Cannot be rooted in the rigid economic ideology. Why? What is the reason? As the nature of economy, write down, as the nature of economy, as the nature of economy has transformed, as the nature of economy has transformed post-liberalization in bracket since 1991. In bracket, write down, from a socialistic model to a market-based model. From a socialistic model to a market-based model. Is that fine? So at one point, your interpretation of the articles has to be made by the judiciary, keeping in mind with the times that you are living in. These clauses cannot be sealed in a fossilized perspective. Constitution is a living document. And it further says, Constitution writes what? It says what? Present judgment, if you look at the letter of the Constitution, that says what? Constitution in 39B says what? Material resources of community. It does not mention material resources of the state. Then it would have meant clearly owned by the state, which is not the case. Then only these state resources could have been used by the government for common good. It does not say also what? It does not say material resources. That automatically means what? It automatically means, it says material resources of community. समाज के resources, समाज के संसाधन. ये तो नहीं बोला ना सरकार के संसाधन, या सिर्फ संसाधन भी नहीं बोला, जिसका मतलब निजी संसाधन आपके और हमारे, which means private property would have been automatically a part. Thereby the court said not all private property under material resources can also be interpreted from what? From letter of the Article 39. Letter of 39. Which does not mention material resources or material resources of the state or material resources of the state. What is material resources indicating? Had we written material resources for the common good, then this would have meant what? This would have meant private property. Material resources of state would have meant what? State property. But what is the Constitution saying? Material resources of the community. It says community, that's like a middle path. That is why CGI said that it is not all private property. What property I have not commented till now. I'll do it in the end. And further point, is it clear, yes or no? Further, the court ruled. Justice Iyer's interpretation is, you tell me. Justice Iyer's interpretation, tell me, lawyers. Wrong. Yes. I know it is wrong. I expected something big. I will not disagree. Yes, it is wrong. बस बोल दिया wrong. उसके आगे कुछ मत पूछो, बस wrong है. मैंने कह दिया तो कह दिया बस. That's good as an adhikari, but we have to argue. I have discussed it. How? What? The feelings, the heat. Then what? बताओ. Is incompatible with Article 300A, which guarantees. Understood? Article 300A, which guarantees what? Which guarantees right to property. So, if you say that, listen to me now, you try to understand, इसको समझिए पहले. If you are saying that every private property is a material resource of the community which can be acquired, material resources of community as said by Mr. Iyer is private property, which means private property can be acquired at any point by the state, isn't it? To fulfill common good. Then what is the point of having a right to property in the Constitution? You have right to property in the Constitution, which is a right given to you by the Constitution, saved by law, otherwise by law. By law, the property can be acquired, it can be given as a compensation to you, but saying it clearly in the Constitution that every private property will come under material resources of the community, that automatically says that this Article 300A becomes redundant. It cannot be implemented. It becomes incompatible with the provisions of 39B. 39B can be subject to interpretation, but 300A is a clear letter for which there is no outright debate that can take place. 300A clearly says no right to property. That is clear. Unlike 39B that says that whether private property comes under material resources of community, that is subject to debate that we are doing in the courts. So this is clear, that is unclear. If you make it completely clear that is unclear, then automatically this 300A becomes redundant. Right? And now comes the test. Write down the test. Test what? The test of what? Prelims. Test of private property coming under material resources of community. Coming under material resources of the community. How to determine which private property will be coming under the banner, under the ambit, under the scope of material resources of the community? That is what we are discussing. Right? Now see what the court said. Write down first part. The private property first thing, the private property has to be, number one, a resource. For private property to be coming under the material resources of the community, whether every private property comes, no. Some private property will come, but before that, that private property, number one, has to be a resource, ek sansadhan ho. Second, it has to be tangible. It has to be a material. This is a private property. Tangible private property. It has to be a resource and it has to be a material. And the following समझ में आ रहा है? And the following is the list of non-exhaustive factors. Non-exhaustive factors. Non-exhaustive means not all the factors. This is just a start that the court has given. List of non-exhaustive factors, because at the end of the day, the court has become powerful. The court has not given a complete list, it has just given you some of them. Following are the what is the sentence? Non-exhaustive factors under which private property shall come under material resources of the state. Number one, first factor. What is the nature of the resource and what are its characteristics? What is the nature of the resource? What are the characteristics? Is it essential? Is it essential for who? Well-being. Is it essential for well-being of community? क्या जरूरी है? वो private property for community, scarcity of such private property, scarcity of such private property. Is it scarce? Number 4, if it is concentrated in few hands. If it is concentrated in few hands. These are some of the factors that the court has said on the basis of which the private property can be acquired by the state to do what? To perform the public good, which is a directive principle of state policy given in the Constitution under the Article 39B, under Part 4, Articles 36 to 51. DPSPs which are non-enforceable, which are non-justiciable. So the story that started from 1977, Mr. Iyer saying every private property rooted in his economic ideology in 1977, we were a totally socialistic economy, state could acquire everything for the welfare of all of us, the common good, has utterly changed till now, where number 1, not every private property. Which property? Number 1, it has to be resource, it has to be material, and then apply these criteria, please. Then after that, you've also seen that your judgments cannot be based, interpretation cannot be based in economic ideologies. Third, what you said, the letter of the article itself writes not material resources of the state or material resources, just says material resource of the community. And finally, the interpretation of Mr. Iyer is what? Is wrong or incompatible with the very right to property that all of us have in the Constitution under Article 300A. I hope it is clear. It's a tough judgment, I know that. So 2 questions were raised. First was, what is the scope of 31C post the Minerva Mills case 1980? We go back to the 1973 case, 1973 scenario. Entire 31C did not get struck down. And what private property? Not all. Which one? This is the list of non-exhaustive factors. Right? Right? Yes. Yes. हाँ नहीं material resources of the community दिखाना, just check once. Okay, show me. I want to see the notes. Oh, sorry, yes. Material resource of the community कर दीजिए. इसमें you are corrected. Material resource of the state, strike of state, write down community. Material resources of the state, strike of the state. Exhaustive factors under which private property shall come under. Material resources of the state is what I made you write. Please, strike of state, write down community. State, strike of state, write down community. It's not state, that's my, must have come by mistake. Okay, fine. Is it fine? Okay. Is it fine? Understood? Now let's analyze this judgment. Let's analyze the judgment. We need to analyze this judgment. What's the first analysis that you want to make? Very interesting. As a citizen, you all are feeling a bit disoriented in the past 30-40 minutes. Is it because of the temperature? Is it because of the judgment? Or is it because of me? Temperature we've regulated. Is it comfortable now? Okay. Now tell me, what is your observation?
Well, right.
Yes, right to property. What? Right to property is always a constitutional right, but the court recognizes the fact that the DPSPs have to be seen from an ideological framework that is subject to change. Isn't it? Don't you agree with me? What is DPS? What is 39B? Starting from Justice Krishna Iyer and Ranganath Reddy till 24 and 50 years, a lot has flown under the bridge. So we need to write in that perspective. So you write down number one. Write down. You write like this, that first point. Interpretation of DPSPs. Interpretation of DPSPs cannot be seen through a particular prism of economic ideology, is that fine? And something very interesting which is rooted in the very lyrics of Article 39B. Tell me. No, something about the letter of 39B. Write down. Article 39B has been 39B has been what? Has been broadly worded. Has been broadly worded to ensure flexibility. To ensure flexibility. Where? Flexibility in interpretation. And not tie it with a what? Not tie it with a particular ideological thought. Also, you can write down. Now, see, this is very interesting. I want to just also discuss about this point. That, see, now, if you look at this logic, I hope you understand. In 70s, everything was regulated by the state. Look at space. Look at defense manufacturing. So, the very lyrics of this article are in such a manner that when the times are changing, today we are living in an era of, let's say, complete privatization. Let's say 50 years down the line, you never know, some new philosophy comes up, and then again this case goes to the Supreme Court, and this interpretation might become redundant. This interpretation is allowed by the letter because there is some gray area which is left. That is why the Constitution is giving me flexibility. Had you simply written it like this, that material resources of the state, then it was a full stop. It's a clear argument. Private property is a constitutional right that is clearly given in the Constitution. That's given under where? Under Article 300A. So this article has been worded by the makers of the Constitution to allow that flexibility, that as and when the economic ideology changes, the economy changes, so will change your interpretation. And mind you, What private property is coming under the banner of material resources of the community? The list is non-exhaustive. So as a matter of fact, if there's a dispute where a private property gets acquired, as per the state, considering it to be falling in that criteria which is non-exhaustive, or it might have its own criteria, who will have the last laugh? Judiciary. So in a way, you can sense that the judiciary's power to review have got increased, and where the Supreme Court or the courts, judiciary will decide on a case-by-case basis that whether a private property is coming under the ambit of material resources of the community and thereby acquired by the state for the common good. Do you agree with me? Write down this point, third point. Finally, the powers to determine if private property is material resource of the community, shall finally lie with the judiciary. Which shall determine on a case-by-case basis. Right. So what started from Justice Iyer, that was a minority opinion. There is no harm. That judgment clearly had said, that 7-judge bench has clearly said that private property is not material resource of the community. But Justice Iyer's opinion became the thought for the judges in the future. So that became economic ideology for judges, like the case that you saw here. Which case you saw this? You saw this case. Which one? Yeah, after Ranganath Reddy, you saw this case. Yeah, Sanjeev Coke Manufacturing, and you saw Mafat Lal case. It became the order. It became what the court had followed. But eventually, what I want to say is that doubt that this decision has been adjudicated by a 9-judge bench. To settle this entire debate, we referred in 2002 to a 9-judge bench. But this thought of Mr. Iyer in Ranganath Reddy that prevailed over the Supreme Court benches over the year. Is it fine? So it is not, yes, I can say that 39A is a socialistic provision. I can surely say that. But interpretation of 39A also has to change with the direction of the economy, which might change in future. Is it fine? Any doubts? Which, no. How can the minority opinion be upheld? In Ranganath Reddy, it was a 7-judge bench. The majority opinion said that private property is not material resource. But what Mr. Iyer had ruled, this became the thought for the future benches. They did not uphold. That was a separate case. But in Mafat Lal case and in Sanjeev Coke Manufacturing case, this idea was taken further ahead. They picked up this economic thought that resources of the private property will come under material resource of the community. But to finally address this thought and kill it, we had to go to a 9-judge bench. That's a present case. That is what we did in 2002. Is it clear now? So that thought prevailed in the judgments, which finally has been put to rest after this case came out. The dissent opinion was there. Dissent opinion is not relevant. One of the judges had dissented and he said that this should have been left to the legislature. what is a private property, and that private property is coming under the dimension of this material resource of the community. That's not the court's job. And Justice Nagratna also said that such a critical remark should not have been made by the ex-CJI, the erstwhile CJI, when he gave the judgment and he struck down the Ranganath Reddy observation of Justice Iyer. But that's a different thing. That's not important. And that's not in the discourse also. It's not right for me to say, because it's a dissent opinion by one judge, that it's not the job of the courts. It should have been kept to the legislature. Just know that that's his opinion, but that's not important here. Is it fine, all of you? Should I go ahead? So with this, we are done with the first leg of the classes. We are done with your portion of topics. I could have taken SEO also, but I think you would be clogged in your heads. See, this idea, why did the question of striking down entire 31C came up when Minerva Wills debarred judicial review? This is actually because it came up in April as a question, and when a case comes up, sometimes these questions are raised where the court itself is not sure. I have simplified it for you so that you can easily understand, and that is why you are saying that how can it come up like this, but there can be many more nuances, and because of that there can be lack of clarity, and that is why we have this 31C coming up as a question. It was framed only in April in 2024. The primary question was interpretation of 39B, if private property is coming under the ambit of material resources of the community. Karthik, I hope it is clear. Sankit, I'll answer your question later. Yeah, so I was saying, Risha, that what question can come up in the mains like this? The questions that will come up, they should be a straight question coming from this area, because the point I'm trying to make is it is a tough judgment. So this judgment cannot be seen by you with another judgment. Like when I had taken AMU and madrasas, I had put it under the banner of minorities. That same thing cannot be carried here. It's an all-in-all complete judgment that opens up an entirely different flavor for the examination. So it can be asked in a straight manner in the examination. Hey, just 1 minute. Is it clear, Risha? Give me a go ahead. Risha, is it clear? Yes, this was a 9-judge bench. I clarified. 2002 here means that in 2002 it was referred to the present 9-judge bench that got finally decided after 22 years in 24. Is it fine? Yes. हाँ, वो इसमें रेलेवेंट नहीं है. वो हो सकता है कोई केस हो. नहीं. प्रीलिम्स में ये नहीं बोलेगा which of the following is common good. ये चीज नहीं पूछेगा. इसको पूछ सकता है प्रीलिम्स में, क्योंकि एक तो टफ जजमेंट है. इसका प्रीलिम्स में पूछा जाना बहुत मुश्किल है, बिकॉज कोई ऐसी लिंकेज निकलती नहीं है जिसको वो पूछ सकता है. वो ये पूछ सकता है कि 39B कौन से पार्ट का है, किस किस्म की डीपीएसपी है, बिकॉज डीपीएसपीज भी अपने आप में 3 किस्म की होती हैं, गांधीयन है, इंटेलेक्चुअल है. तो उस डायमेंशन से पूछ सकता है, बट स्ट्रेट क्वेश्चन नहीं पूछेगा. या फिर आपसे फंडामेंटल राइट्स और डीपीएसपी का डिबेट पूछ सकता है, जो कि स्टैटिक पॉलिटी का पार्ट है. ये 39B का इंटरप्रिटेशन का डिबेट है. अभी तक आप 39B को बस देख रहे थे और इंटरप्रेट 39B को समझ रहे थे कि भाई ये स्टेट एक्वायर कर सकता है प्रॉपर्टी, और 14, 19 और 31 अब नहीं है, उसको ओवर पार कर सकता है. इसका डिबेट हमने पढ़ा जजमेंट में. अब हम ये देख रहे हैं कि 39B का अपने आप में स्कोप कितना है. डू यू अंडरस्टैंड? मोस्ट वेलकम.